1905, the Commissioner of Patents, somebody said, everything that has been invented has already been invented. When you talk about the numbers hitting 7.5 million,
I mean, that patent, the head of the patent office at that time said, close down this operation. It's done. We've invented everything. And that was about the turn of the century. I think there have been some things created since the turn of the 1900s, not 2000. So there's new stuff coming out all.
my question is, what is not patentable?
I would turn to patent attorneys to give you a good thing like that, but it's what doesn't hit the criteria of non-obvious, and a valuable technology to the world. I mean, there are criteria that are established, but they're words, and they can be interpreted. And it's based on having a good patent attorney review what your invention disclosure determines to see if there is something patentable.
But I'm wondering if the categories like plants or anything like that.
Plants have been patented, mice have been patented. Okay. Harvard did that with the transgenic mice most years ago. I mean, there are certain things that are more easily, drugs, therapeutics, things like that, electronics, technology, but business methods, which were ones that were patented only a few years ago, pretty much now have a new requirement that they have to demonstrate that they use technology in their solution, in their solution of providing the technology. And if they don't, if it's just something that's handwritten or somebody who's linking two numbers together, it won't be patented.
It's basically a thinking process. You can't patent the thinking process itself. You have to use technology to do things. So then write software to duplicate your thinking process.
Make sure it's used on a machine.
Like iTunes is a business model, but it's enabled by technology, so I'm sure it's patented.
As you pointed out, patents aren't the only way to protect your intellectual property. There are, a lot of software in the U.S. is covered by copyrights, and a lot of things are trade secrets, which if you can't reverse engineer them, if it's a type of process which you're going to use over a long period of time, it's more useful to you actually not to disclose it to others and to keep it a trade secret. I mean, there's a reason Cote has never attempted to patent its formula, and that you'll find that for a number of products. Anything that's difficult to reverse engineer, why tell everybody how you did it? Because then 20 years from now, you have to come up with a new way.
Other questions?
I have two questions actually. First is, do you see patent donation as a competitive advantage? Because, for example, if it is your non-core IPs, you can actually donate it to third parties, right? Like universities, and get tax reductions.
There used to be a way of doing it. The IRS has made it so onerous and placed so many restrictions on the value that you can claim. In fact, 10 years ago, some companies put some very high valuations on their donated technology. The IRS came back in several years later and said, no, that valuation was way too high, decreased it, and they were forced to pay additional taxes because they'd taken it as a write-off. Mm-hmm. So donating IP to universities right now is very difficult. It is still being done, but the valuations are much lower than they once were.
Yeah, and the second question is about cross-licensing. How do you view that? For example, especially in technology,
in some
intensive industries.
verticals, like electronics, it is a necessary fact of life. In others, like pharmaceuticals, it's practically never done because one drug is defined by one patent. Okay, it depends on the vertical you're in.
Just your comments on trolling and Mendelssohn, as a big one, of course. Is this
Well, Mendelssohn was a special way. He was doing submarine patents. And what a submarine patent is you submit a patent application, but you keep it in application for years. So you're always going back and forth with the patent office. You're adding something or subtracting something, but it never gets awarded. So that you've created something like Mendelssohn did, say, in 1950, but the patent doesn't come out until 1975. Well, the whole fiber optic market was created during that period of time, and he had some very early conceptual patents that covered that. And he was able to make some money. He had some money, he had some patents on barcode at the very early days. And so it's a technique that the patent office has put new regulations in saying that you can't have these endless continuations of the same patent and keep the same data.
And now the fact that they made the definition 20 years
Right.
from filing.
Yes.
If you want to continue for 20 years, that's fine before it gets issued, but your period of usefulness after its issuance is
Just
0.
1 year. So that they've essentially eliminated that just because of limits. The trolls are different, where they have actually bought IP and then are strictly trying to find people who might be stepping on it in the most, innocent ways. But if they can find something close, you can't sue them. They don't have any products. Their only ownership position is owning the patent. And so they're in a very protected position. But they're fighting a legal right. They have a legal right to do that. So they're not doing anything against the rules. It's just they're using the rules for their advantage.